The fact he had firearms in the home, well, you're not allowed to have firearms and illegal drugs in the house. Whether or not you agree with that or not, that is what the law currently is, and he was charged with that. He was also charged with having children in a home with a bunch of drugs as child endangering. Once again, you can agree or disagree, but that is currently the law. Now, the last two charges are misdemeanors. He faces up to a year in jail on those. The bigger charge is the 26 grams of cocaine. And he faces up to 25 years of prison on it. Now, would he ever get 25 years of prison? No. There's a lot of presumptions and a lot of statutory judicial interpretations that the worst case scenario he's looking at is some sort of probation sanction to begin with, and they would not send him to prison right away. So those of you who are worried about him going to prison, that's not going to happen. I've said that from the start. Those of you who are hoping he goes to prison, that's not going to happen. I've said it from the start. So Nick went through many things, and if you guys go back and watch through it, I need to re-update the Rekieta collection, my own curation of all my videos. Nick challenged his search warrant on the grounds of the police lied or were completely lied on completely erroneous information, which is something he could challenge under a Supreme Court ruling known as Franks v. Delaware. And that's set out, and you've heard it talked about the Franks hearing. Well, Nick filed his motions, and if you've paid attention, I critiqued them. They were absolute hot garbage. One of them was disorganized hot garbage, and the other one was very well organized and streamlined hot garbage. So what happened? Well, the court looked at all of it and said, nope, Nick, you lose. You're done. We're not having a Franks hearing. I don't believe the cops lied or relied improperly on any information. In addition to that, Nick then was also precluded from raising any other issues because I know Nick's saying he didn't do it, but as Nick has mentioned, apparently his lawyers aren't the best, which I don't know why you're still using them, but it's just me. They missed a bunch of other things they could have argued, and then they're now precluded from bringing those issues up. So what happened from there? Well, Nick filed an interlocutory appeal, and we covered the interlocutory appeal earlier when it got filed. An interlocutory appeal is basically asking a court of appeals to make a ruling on a trial court ruling mid-trial, midstream. So literally you're like trying to hit pause on your court case and have the Court of Appeals figure out what it wants to do. Now, those are discretionary. You're not entitled to them. Now, there are times where there are very good reasons for it. So a very good reason of that was the Trump v. United States case about presidential immunity. Issues of immunity are kind of a big deal because if you're immune, then the case dies right away. There are times where you have very novel issues, or there's an issue that was clearly wrong, something like that. There's going to be and then there's other times where the court has the ability, and even that it's discretionary. But those are more compelling cases. And Nick tried to make the argument, look, I've got a compelling argument. Well, the Court of Appeals offered its opinion, and they said, not so much, not so much. And we're going to take a look at that. I think this there's a lot. It's only 4 pages long, but it says so very much. It says so very much. And we're going to start with this. No, hold on, I got so many tabs here. All right, chat. So this is it. It's the state of Minnesota in the Court of Appeals. State of Minnesota versus Nick Rekieta. And this was decided by a couple different judges. By Judge Segal, Judge Wheelock, and Bentley. So they said, based on the file, record, and proceedings, and for the following reasons. And then they go through the basics. Nick's charged with second-degree drug possession, unlawful possession of a firearm, and child endangerment. Based on evidence after a search warrant was executed at his house. And he talks about it. He moved to suppress the evidence and dismiss the charges under Franks v. Delaware. And they wanted to they want to investigate whether the search warrant application contained material misrepresentations regarding the social media video. Once again, we're getting back to my watermark. But yes, the watermark nonsense and, oi me mate cog.
And you know what I found? Evidence. Evidence, guys. We're going to go through how Andy Warski was at the Bellagio from the 9th of June to the 12th, I think it is, or the 13th, 8th, 9th June to the 12th, I think it's 12th or 13th.
Uploading the videos. I don't know if Cog's not my mate, but I don't know. I tried to do the British accent, chat. So anyway, the district court denied the motion for a Franks hearing, and the petitioner seeks discretionary review of the order denying the motion for a Franks hearing. Remember, it's discretionary. The court could say, yeah, we'll take it up, or they could say no. This is not an appeal of right. After the trial is over, and after a case is over, your criminal appeal is an appeal of right, meaning you have the right to file the appeal, and they have to take it under consideration. Now, they may end up saying your appeal is garbage, but by law and by constitutional right in many states, you have the right to appeal at that point. You don't normally have the right to appeal midstream. So the petitioner argues this court should grant discretionary review in the interest of justice because the Franks issue is important and doubtful, and resolution of the issue would obviate the need for further proceedings. Now, here's the big thing. The state has not filed a response. Now, normally, when these types of things, the state probably should have said, like, Your Honor, we don't file a response, we waive it. They didn't even bother to do that. They're just like, we don't give a shit. They read Nick's motion and were like, yeah, these guys are going to lose. They weren't even bothered to waste their time. They have other things to do. They had better things to do than respond. That's a sign, chat. That's a big sign. They're like, you know what? I know Nick was making jokes. Oh, Krista Pierce had to learn how to type. Well, buddy, she didn't even bother wasting time on this. She probably went and took a dump instead of wasting time responding to this.
Sitting on the toilet. Sitting on the toilet. Sitting on the toilet.
That would have been more productive. Because, oh boy, that's never a good sign when the state's like, yeah, I don't want to do this. This is a waste. This is a joke. I mean, you know what they could have done? They could have sent a response in and just went, the state's motion is LOL, bruh. That's what they could have done. I mean, if I was a prosecutor, this probably would have been appropriate. Lol. 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 Now they point out, moving forward, acknowledging it's just Nick. So remember, now it's a one-sided argument. There's not even another side to argue with. The state's not there to shoot them down. It's almost like an open goal. The state was up there. They pulled their goalie.
Here for the Oilers. Bergeron fans on a pass. Stefan steals and he'll ice it. Oh, at least I thought he was gonna until he blew it.
They pulled their goalie, chat. They didn't even bother to defend the net. And Nick and the Barnswalker, they got the puck. Time's running out. So the court points out criminal defendants don't generally have the right to file an appeal until final judgment has been entered. But the court may allow an appeal from an order that's not otherwise appealable in the interest of justice. And you see these rules here, Minnesota Rules of Criminal Procedure. Then you see them citing the Minnesota Rules of Civil Appellate Procedure. These rules are important. These rules govern how you file things, the way things have to be done, especially rules of appellate procedure here, chat. Those are very strictly construed for the most part. Criminal rules, yeah, you could even then you have to color within the lines. Courts generally adhere to them. And there's tons of case law that flesh out your criminal rules, but your appellate rules are also fleshed out very well with a lot of case law, and courts are very stringent about that. You don't get to fuck around and color outside the lines on appellate court. You are stuck following the appellate rules of procedure. Okay? So you're going to see why that's important and why I point that out. In determining whether to grant discretionary review, this court considers multiple factors that include whether the ruling is questionable. Like I said, is it clearly wrong? Or does it involve an unsettled area of the law? Meaning, is it a novel issue? We've never dealt with it before. So it might be kind of important. The importance of the legal issue presented. Once again, is it something like the president arguing whether or not he's immune? and whether the issue would evade review if the appeal is deferred until the underlying case has been decided. Now, that generally, I mean, you can preserve the appeal. That's a very rare thing there, but it can happen. So, discretionary review is only extended to important legal questions that have broad applicability. So, if there were, and I know Kurt had mentioned this, and it's a good example, there are like 15, 20, 25 other cases in Minnesota right now with this exact same issue. That's a big deal, because that means we're going to have to take care of it at some point. And it's probably going to be an appellate problem. You know what's easier? We take care of it now. Because it's probably going to keep coming up. But this is not one of them. The petitioner must also show a compelling reason for his court to grant discretionary review. Now, the petitioner, and here's the issue. The petitioner does not explain why the district court's pretrial ruling denying the motion to suppress evidence and for a Franks hearing require this court's immediate review. Like, they literally did, and I agree. They don't explain why. Why? You have to tell the court why. Like, why should you hear this? Why is this important? And notice, the Minnesota rules of civil appellate procedure. Okay? And it's requiring a statement why an immediate appeal is necessary and desirable. You didn't even follow the fucking assignments, chat. And here's the thing, they point out, Minnesota rules govern the procedure for an appeal. All right, so what does 105.2 say? You have to provide why you have to do this. It's like taking a test and not putting your name on it. It's kind of like step one. Why should we? Here's why this is important. Why is it necessary? I mean, that is a complete whiff.
Fucking shit, fuck me in a...
You fail step one. You know, you get ready in the blocks, and all of a sudden, here comes the starting pistol, bang, and you just flat face down on the ground. You don't even move. Like, literally. Just eating crap right off the bat. I mean, this is kind of like, you know, and this is, I guarantee you, this is not a brand new rule. Not a brand new rule. But this is why you have to know what you're doing. If you don't follow the rules, the court's like, I can't fucking help you. They also point out, moreover, this court generally does not grant petitions for discretionary review of pretrial rulings because the defendant can utilize the procedure in Minnesota Criminal Rule 26.01, sub 4, which permits expedited review of a pretrial ruling that is dispositive or would make a contested trial unnecessary. So they had another vehicle. They had another option, another vehicle to do this. Why aren't they doing it? I don't even know if they can do it now. Maybe they've waived that opportunity by filing this. I don't know. I mean, as soon as this was filed, I hope Nick's attorneys are pouring over Rule 26.01 sub 4 and be like, can we do this? Because, like, Nick, too, I know he's out reading all those abstracts, but he needs to shift gears from reading, about chemistry and organic chemistry and whatever else he's been reading, getting back to the law. What can they do now? Because what do you do? I don't know what the option is. I don't know how this works out there, but I get the feeling it's not good, especially when you consider you have your pretrial hearing next week. So you better get on it. But they point out there are issues here. I mean, because Nick could go ahead and show why he shouldn't be required to proceed by stipulating the facts, waiving a jury trial to obtain review of the pretrial ruling. Yeah, well, there you go. That's part of the issue. I don't think Nick would agree to the facts and waive a jury trial to obtain review of the pretrial ruling. I mean, how confident are you, Nick? How confident are you? Just saying. Like, I don't know if you're that confident. But I don't even know if they could do this still at this point. It's not clear. And although review would be somewhat delayed by requiring petitioner to appeal from any final judgment, the pretrial ruling will not evade review. And a defendant's interest in avoiding the time and expense of trial does not by itself establish a compelling reason to extend discretionary review. Nick has not otherwise shown a compelling reason for this court to extend its discretionary appellate jurisdiction when the pretrial issues are fully reviewable in any appeal from any final judgment. Therefore, it is denied. Again. Although this court's nice, they kept it in lowercase and they didn't bold it, but like, denied!